Greetings everyone. First of all, I would like to thank the organization of this event and in a special case the Dr. Flora Charles for the opportunity to be in here speaking to you about Brazilian criminal procedure, about Brazilian criminal justice in the honorable condition of key speaker. In addition, I'd like to ask you your comprehension, your understandings, because English is not my mother language, so for me it's not so common to speak in English, so I hope you understand my difficulty sometimes. I am Rodrigo da Silva Brandalize. I am prosecutor in Brazil, a state prosecutor in Brazil. I am professor of criminal law and procedure law at Fundação Escola Superior do Ministério Público, where I am now recording this lecture. And I hope you may enjoy and have some important information about Brazilian situations right now. Well, when I was invited to give this lecture, I decided to talk about my situation because I am prosecutor in Brazil, and specifically speaking because our most important role is to promote privately the criminal prosecution according to the law. And nowadays we are facing an important problem that the discussion about it doesn't happen in a good way, in a real way about our problems here. I live in Porto Alegre. And I work in Porto Alegre. Porto Alegre belongs to the state of Rio Grande do Sul, the southernmost part of my country. When a judge decides in Porto Alegre, it's possible a first level of appeals to the Court of Justice in Rio Grande do Sul. After that, it's possible a second level of appeals to our Superior Court of Justice. And finally, a third level of appeals to our Supreme Court. Both Superior and Supreme Court are in Brasília, our capital city. Because of that, and for sure, for the number of cases that prosecutors work specifically in Rio Grande do Sul, last year, for instance, we have much more than 2 million cases in Rio Grande do Sul. We are having to regulate or to face, as I said, important situations involving the number of crimes. For instance, last year we had more than 8,000 first hearings, preliminary hearings involving pre-trial detentions in Brazil. Oh, in Brazil, no. In Rio Grande do Sul, much more than 8,000 pre-trial hearings or first hearings because of pre-trial detentions. This number shows how many crimes that happens in Rio Grande do Sul, and you may calculate it in a proportion to the rest, about the rest of our country. So, as I told you before, we have 3 levels of appeals, using as a reference Porto Alegre. And our procedure has a lot of steps. In sum, we have 12 steps. report, the inquiry, prosecutors files of the charge, judge receiving the charge, the summons upon the defendant, defendant answer to the charge, confirmation of the charge, notifications, hearing, some measures that are necessary before the closing arguments. After that, the judgment, appeal courts, execution of the sentence. Okay, in general, 12 steps. But, as I told you before, 4 levels of appeals. And we have a lot of appeals. I would like to show you some of them in red. They were red in red. Motion for clarification, ordinary appeal, internal interlocutory appeal, special appeal to the Superior Court of Justice, extraordinary appeal to the Federal Supreme Court, interlocutory appeal in a special or extraordinary appeal, appeal against a divergent decision. So there are a lot of appeals in our system. And consequently, I want to show you 2 examples about this problem. This one, translating motion for clarification, in 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 regimental interlocutory appeal, in special appeal, in motion for clarification, in motion for clarification, in motion for clarification, in regimental interlocutory appeal, in special appeal. 11 appeals, 11 kind of appeals, but in the same court, only in Superior Court of Justice. In the second example, translating this, appeals between August 2019 up to June 2021. 2 years only discussing appeals in the same court, Superior Court of Justice. As you may see, regimental interlocutory appeal, in motion for clarification, in appeal against a divergent decision, in motion for clarification, regimental interlocutory appeal, appeal against a divergent decision. So far, 11 appeals, again, in the same Court of Justice, Superior Court of Justice. So, sometimes we have in the same court more or less 11 appeals. But it is an example. It could be at our Supreme Court. It's possible to have 2 or 3 appeals in Court of Justice to decide the same, to discuss the same decision all the time. So, we have a difficult system of criminal justice here. And of course, it has a lot of consequences. I listed 4. Consequence 1, because of our Constitution. According to our Constitution, no one is considered guilty until a definitive conviction. So, consequence number 1, the defendant and his or her lawyer may file countless appeals to delay the definitive conviction. Because we must wait the definitive conviction to begin the execution of the punishment. Before that, it's not possible. Sometimes we have pretrial detentions, but in general, execution only after definitive conviction. Consequence number 2, we have a low efficiency of the conviction until the Superior Court's decision. The judge in Porto Alegre, for instance, it could be São Paulo, Rio de Janeiro, Brasília, and any other city in our country. But the judge in Porto Alegre has less importance in our system of justice. Specifically, system of criminal justice. Consequence number 3, there is a predominance of pretrial measures. We do not have definitive decisions, or much more definitive decisions. We have predominance of pretrial measures because the judge in Porto Alegre must do something quickly. He knows the urgency of the case, and his decisions that are much more pretrial during the investigation has much more effect than the definitive decision. And consequence number 4, we have an improvement of consensual measures, but in Brazil we have a predominance of diversion measures with no guilty discussion. It is easy in Brazil to run away for the conviction, either because of the diversion measures or because of our appeal system. It's easy to run away, to escape for the condition. As a TV series, How to Get Away with Murder, it is easy sometimes to get away with murder, rape, drug crimes, money laundering crimes, and so forth. We do not have in Brazil guilty plea, nolo contendere, as American system has. Of course, we must have a lot of budget, a lot of money to try to stabilize this criminal system. And to finish that, because my time is finishing, I would like to say again that our diversion measures, we have diversion measures without discussion or determination of guilt and punishment. Sometimes conditions like pay an amount of money, do a social service, something like that, but no determination of guilt. To finish, I would like to say we have some important problems in our criminal justice system. We have a lot of problems in our criminal procedure law, and it's necessary to show it because we need to learn much more about that around the world to improve our discussion in Brazil. Thank you for your attention. Thank you for any kind of contribution that you may send me in the future, and I'm here for any kind of other discussion. Thank you all.